Welcome to More Financial Talk. I'm Ryan Moore, and today I've got my co-host with me, Tony Shore. How are you today, Tony?
Oh, I am doing great, Ryan. Thanks so much for having me on your show today. You've got a great topic lined up. There's so much going on out there in the world of finance. I'm glad we do this each week to stay updated. I always learn something. How have you been?
Yeah, doing well. Just plugging along. Just meeting with lots of folks, and what I say is keeping the conveyor belt moving. So.
I like it. I like it. I know you're really busy. Well, let's jump right into our topic today. This is a big one, beneficiaries. And people are thinking, what's the big deal about beneficiaries, Ryan?
Yeah, I think there's a lot more to this than many may realize, and it's stuff that I get to see firsthand every day. And when it's meeting with new folks that I haven't been working with, sometimes we uncover some pretty interesting things or things that they didn't realize, and then there can be some pretty big missteps in all this too. But in addition to all that, our financial industry and our markets in general are always changing, right? It's a moving target, and you get new
Right.
legislation that comes in, and that can impact some of the rules as it relates to how people receive their inheritance depending on the types of accounts. And so that's something we definitely want to touch on as well.
Yeah. Well, I think that's good. And I think a good place to start is probably some of the basics of beneficiary designations. I know you've seen a lot of mistakes. You were just telling me before the show about people will come in and they've made some costly mistakes with their beneficiary designations. Is that correct?
Yeah, so like you said, let's hit some basics here. So first of all, I think it's important to always make sure that you know that your beneficiary designations are first and foremost in place, right? And then secondarily, just double checking to make sure you've got the people you want, the percentages of distribution to whom you want those resources to go to. But also understand when it comes to the world of beneficiaries, there's a primary beneficiary and there's also what's called a contingent beneficiary. So in a pretty normal situation, when you've got IRAs, for example, and you're in a spousal situation, typically you're going to name your spouse as the primary beneficiary, but you don't really want to stop there, because what happens if something happens to you and your spouse at the same time? And one thing to understand about beneficiaries is that they avoid probate, and that's another factor. So by having a designated beneficiary, it's essentially assigning ownership at your death and therefore becomes a non-probatable situation. But if you just have your primary on there and your spouse, and there's a tragic, maybe car accident, for example, and you don't have your kids on there as contingent beneficiaries, now there is no assigned ownership at death, and that would cause a probate situation. So you always want to make sure you have your secondary beneficiaries, which are also known as contingent beneficiaries. So that's some of the first basics that we want to touch on.
Yeah. Okay. So all of those things are very important. I remember hearing a story about a guy who got married really young and, right out of high school, didn't work out and was only married a year. But he had a good job that he had landed and put, right before he got married or right after, and put her as the beneficiary designation, just listed her and on his 401k and IRA, and then let that grow. But they got divorced, he got remarried, had kids. Years down the road, when he passed, his wife and kids went to get that, and the beneficiary was the ex-spouse from years ago or years earlier,
Yeah,
and
yikes.
they took it all the way to the Supreme Court, and it didn't. The Supreme Court says a beneficiary designation takes precedent over the will, right?
Yeah, that's correct.
So even if it's in your will differently, if the beneficiary designation, what that says usually goes, right?
Yeah, because it's a direct assignment, essentially. So yeah, these are
Sure.
things you need to keep up with. It's not so much a set it and forget it. Let me give you another scenario, and this is one that I just ran into recently. So what many people don't understand is when you have an investment account, which is what's considered a non-qualified or an individual or joint account, meaning non-IRAs, right? So an after-tax mutual fund account, brokerage account, something to that effect. If you work with an investment advisor and you set up one of those individual non-qualified accounts, typically in our industry, the application for setting up the account itself does not give you the ability to list beneficiaries in that application. So it takes a secondary form known as a TOD form that you have to add to get the beneficiaries on that individual or joint account. And so therefore, if you don't have a competent advisor or they just simply miss it and you don't have the wherewithal to ask, you could get an account set up without any beneficiaries on there at all. And you didn't feel like you missed it because it wasn't on the application, right? So most advisors are going to be prudent in that regard and give that secondary form to put a TOD. And what TOD stands for is transfer on death. So I just recently met with an 80-year-old woman who had an individual brokerage account, and she's single at this point. And ultimately, when we were looking at the account, I could tell that it didn't look like there was a beneficiary on there, because typically the registration, when you look at the account registration, it will say TOD in that account registration, which is an indication that the beneficiaries have been chosen. In this case, I didn't see a TOD, so we dug a little deeper, and sure enough, there were no beneficiaries on that account. She has 2 children, and ultimately, if something had happened prior to catching that, then that is an asset that would have to go through probate before it would just directly go to her 2 kids. So those are some of the things that, are, worth keeping an eye on and being mindful of. And ultimately where I'm looking as an advisor when I'm meeting somebody for the first time, to make sure all those boxes are checked, so to speak.
Right. And you mentioned contingent beneficiaries. It's probably a good idea on most accounts to not only have a beneficiary, but contingent beneficiaries as well, correct?
Yeah, which is really just a backup to your primary. And oftentimes, if you're married, it will be the spouse first and the kids second. But when maybe you're a single individual, either through never having been married, getting a divorce, or being a widow or widower, at that point, you would have your kids as your primary, and then maybe your grandkids as contingent, or maybe a trust. Okay. And we'll get into that in just a second. But I also want to talk about not always investment accounts. So bank accounts. Now, this is another one. You go to a bank and you open up a checking or savings account. They don't ever tell you that, hey, do you want to add a beneficiary to that account? So this is one that probably, gosh, I don't know, 90+% of the time, people do not have beneficiaries on their bank accounts. And that is what is called a POD, which means payable on death. And that's simply as easy as walking into the bank saying, hey, I'd like to add a beneficiary on my checking account. And they're going to add a POD, payable on death. And that, again, has direct assignment of ownership at that individual's passing, and therefore would avoid probate. And it also allows the money to pass along a lot easier, quicker, etc. So again, in my world, these are some basics, but these are things that many people are just simply not aware of.
Yeah, and that's something I hadn't been aware of until recently, is that you could put beneficiary designations on other things like bank accounts. And I think that's so important to do. I think everybody should do it, and make sure you revisit those beneficiary designations, though, on a regular basis, right?
Yeah, I think that's a prudent thing to do. If you care about planning and what's going to happen after you're gone, I think these are all important things. But let's move on to talking about how beneficiaries are impacted when a trust is involved.
Okay.
Because I do a lot of trust work for folks, which is, one of the better known tools for avoiding probate. A will is typically a ticket to probate. And so
Yep.
I meet a lot of folks that over the years have, done a last will and testament once they get a little further educated on, a potential more efficient way to pass on assets. If you're like most people, you want things to pass along as easy and inexpensive as possible. Probate is not the easiest and most inexpensive way. It's time consuming, it's costly, it's also a public process. So a trust, without making this an estate planning podcast today, a trust is really a tool to pass on assets and avoid probate. So certain assets, you would want to make the trust the beneficiary of those assets, and certain assets you do not want to. Okay, so for example, the non-qualified accounts, like I was talking about earlier, the ones that are non-IRAs. So with those, okay, you can make the trust the beneficiary, and therefore it will get paid to the trust. And there aren't as many tax implications typically with those types of accounts because the inheritors of a non-IRA are going to get a step up in cost basis. So for example, if the original investment was 100,000, and at the time of passing, it's now 200,000. So there's $100,000 of unrealized gains. When it passes to the next generation, there's a step up in cost basis. All those gains go away. So to assign it, the beneficiary to the trust, ultimately will allow the trust to tell it what to do with the money. So in the trust, you're designating how you want your assets distributed. So it will flow into the trust and then flow out how the trust tells it to. And you still get the step up in basis, and it avoids probate. And that way it's a more of a catch-all safety net for how to make sure that it really goes the way that you want to. Now, alternatively, if you look at accounts like IRAs, for example, that's a whole different ballgame. So what I would typically recommend with IRAs, if you're married, you make your spouse the primary beneficiary. When you pass away and your spouse takes over that account, they would take it over as their own IRA. So it would not necessarily create a taxable event. It's basically becomes their IRA, and then they follow the rules accordingly going forward. But really, the impact is for the next generation. So if you were to make the contingent beneficiary the trust, right? And so now both parents pass away, the IRA is assigned to pay to the trust. So here's the issue. A trust is an entity, and an IRA by definition is an individual retirement account. So you can't put an individual retirement account into a trust, or you have to cash out the IRA and all the taxes are owed. And that would be a misstep because now you're not giving your children the ability to defer the taxes over time. Or if it's in a Roth, we've got even a bigger situation. So let me add a little background or story to that scenario. So I met with a couple. This was a few months back. They were already clients of ours, and they had gone to a separate attorney than who we're affiliated with. It was kind of a more advanced law firm, premier firm out of Nashville that we're familiar with. And they had gotten a trust set up, and the recommendations from the law firm were to make the trust the beneficiary, the primary beneficiary, and not even the spouse. And that recommendation was to do that on Roth money. So let me tell you what impact that would have had. If one of them passes away under that setup, then the Roth money would get paid to the trust, which essentially means it's coming out of the Roth. And now you just took away the tax-free growth potential for the surviving spouse to keep it as their own Roth and continue to grow that money tax-free for the rest of their life, and then to ultimately pass it on to their kids as Roth, and they would be able to grow it tax-free for another 10 years. So I caught that when they came in and they said, here's what the law office is telling us how to set up these beneficiaries. And I said, okay, well, let's just think this through a little bit. Are you sure this is really what you want? And once we, gained clarity through the explanation, it is not what they wanted. And
Right.
as tragic irony would have it, literally a few months later, the husband, who was a retired Vanderbilt doctor who loved to cycle, he was a cyclist. He had a tragic cycling accident while he was on the road, and he ended up passing away. And so if we had not caught that and didn't fix it appropriately, then ultimately all that IRA money, which, by the way, they were high net worth folks. They were doing very large Roth conversions. So they were doing all this planning and paying taxes early and doing, I think, all the prudent things to maximize their estate and position themselves for tax-free retirement and for their only child to have tax-free benefits. They would have hindered that completely. So those are the types of missteps that can happen if you don't really know what you're doing with these beneficiaries. So when it comes to the trust, you don't really need to involve the IRAs with the trust, again, because they have beneficiaries, they have assigned ownership at your death. So therefore, it avoids probate. And we don't need the trust to function in that regard because it's already going to avoid probate.
Sure. And, I'm glad you talked about that because personally, I knew about the traditional IRA and all the tax consequences, how you wouldn't want to transfer money out of an IRA into a trust because then you'd owe all the taxes. You could let it grow and pay taxes over time would make more sense. But a Roth, I never thought about that you're really taking away the ability to have that growth tax-free because it's already tax-free in the Roth, but you take it out, you no longer get tax-free growth. And that makes perfect sense. But the average person isn't thinking about all these things, right? And not like certain tax professionals like CPAs or estate planning attorneys. They're just, hey, if you put everything in a trust, it's going to protect it from probate. They're not knowing about all this. That's why you need a quarterback, somebody who's got the big picture and works alongside these other professionals to say, hey, here's your overall plan. Does this really make the best sense? And that is huge. That's a very costly mistake.
Yeah, it certainly
could be
can be.
avoided.
I like to refer to it as we like to play chess, where many are out there playing checkers.
Yeah,
So it's about
yeah,
taking the thought to the next level, looking at few steps ahead, and ultimately
yeah.
what rabbit trails can some of these circumstances cause. I want to also say this real quick, Tony, on the IRA, not the Roth, but if you make that beneficiary the trust, you also have to pay the taxes at a trust tax rate, not an individual tax rate.
Oh,
So there's an impact there too. Now, look, sometimes the situation calls for just flowing it all through the trust. Maybe you've got children that are not going to be great with money, or there's substance abuse issues, and the trust is, or special needs child. There's there's always extenuating circumstances and
sure.
exceptions to most every rule. So I don't
Right.
want to make blanket statements here, and just understand
Sure.
there can be exceptions, in which case, it might benefit the next generation to have everything flow to the trust, even though you might be taking it out of IRAs and paying slightly higher taxes. But if the trust is set up to not dole out all the money at once, to incrementally pass it along for whatever reason, then that could be a reason to override some of the things we're talking about because of extenuating circumstances.
Good point. Everybody's situation is different. And
That's right.
that's why before you make recommendations, you're not making a blanket recommendation here. You're just saying there are mistakes that you can make, but you're going to look at each individual situation, each couple that comes to you or individual, say, hey, what's your time horizon? What's your situation with your family? What do you want to leave? What are your goals? So, and that's huge.
Yeah. And so again, anything that doesn't have the tax implications, so non-IRA accounts, no problem sending those to the trust. Also, life insurance. If you set up the trust as a beneficiary to life insurance, well, life insurance passes tax-free. So that's not going to create a misstep either. Or even, again, the bank accounts. You could set up the bank account to have the trust be the beneficiary. And I don't think that's an issue either. So it's just having the understanding and having the right guidance, and knowing that this is important stuff to consider.
Yeah, it's huge. I have a question for you. Do you know if you can leave? What about your home? Can you put a beneficiary designation on a home or leave a home or property to a trust?
So that's a great question. And what I know, and the way I would answer it is this: most states do not allow you to put a beneficiary on real estate. However, there
Right.
are some states that do. And I can think of three off the top of my head, which is Arizona, Minnesota, and Texas. So those states I know allow for what are called beneficiary deeds, where
Yes.
the deed actually shows your beneficiaries listed. And that's very helpful from an estate planning perspective, because that will help the real estate avoid probate. Because if you pass away with a piece of real estate in your name, and the kids need to sell the house or take it over, how can they can't sign your name to do it. So that's what causes probate, because probate is going to be the court process that ultimately generates a court order from the probate judge that gives the executor authority to sign to sell that property, but not until then. So that is one of the reasons why states that don't allow beneficiary deeds, why many do look at a trust. So when you have a trust, you can put the ownership of the home in the name of the trust. And because the house is now owned by the trust and
Okay.
still controlled by the same people as trustees of the trust, but entities don't die. And that's actually why they're called living trusts. And so because entities don't die, you put the house in the name of the trust. Now, mom and dad pass away, and in the trust, it stipulates that the oldest child is now successor trustee. So the entity is giving them authority to sign on the trust asset, and they can do that without probate, sell the house, divide the money, whatever. So to answer your question, yeah, there are certain states that allow that. Most don't. In Tennessee, they don't. And that's why we do a lot of trust work, because anything that we can put a beneficiary on will avoid probate. It's assigned ownership at death. But there's major assets in Tennessee that you can't,
Do that with.
do that with. And it's real estate, or also vehicles or another one, or RVs, or,
But you
things of that nature.
can, with a home or property, do the transfer on death, right? So that you talked about at the beginning of the show?
Not directly, no.
No. Oh,
That's what
okay.
I'm saying. That would be a
Oh,
beneficiary deed. You can't put a TOD or a POD on a deed.
okay.
There is no way to pass it directly like
Okay.
that. The workaround is you quit claim the property to your trust, where you're controlling the trust, but
Sure.
now it's not technically in your name, it's in an entity name,
Yeah.
etc.
I get it. And my confusion there was because my grandfather had a farm in Minnesota, and they said you don't need to worry about going through probate. Your dad gets this land over here because your grandpa had it set up as transfer on death. But we're in Minnesota. That's why he was able to do that.
Yeah, I think Minnesota may actually also be one of those beneficiary deed states as
They
well.
are, I think,
Yeah.
that you
Okay.
mentioned. Yeah. Yeah, I think that's great. Well, thanks for explaining that. As far as beneficiary designations or anything to do with this, is there anything else you wanted to touch on?
Yeah, I think we need to talk about the Secure Act, and that's where we can round out. All right.
Okay.
So the Secure Act made some huge changes, and this is what I, was kind of alluding to earlier when I said, our industry can be a moving target and things are changing all the time. So the first Secure Act, which went into effect January 1 of 2020. And what this did was it changed the rules on inheriting traditional IRAs and impacted Roth a little bit as well. And so prior to the Secure Act, when the kids would inherit an IRA, for example, okay, it used to be referred to as a stretch IRA, meaning when they inherit that IRA, it becomes a beneficiary IRA. And from there, there's certain rules. And if the person that passed away was already at a required distribution age, then when the kids inherit that IRA money, they too have to continue to take required distributions. There is a life expectancy formula for how to calculate the beneficiary distribution on an IRA. Okay. And so the old rule would say you have to take a distribution every year that you own that account. Now, let's say that the distribution is 6%. And it's typically going to be higher than a traditional IRA where somebody's just taking their own RMD, because this beneficiary IRA calculation is more on a life expectancy, which involves the person that passed away and the person inheriting it. So typically it's a higher required amount that has to come out. But let's say the distribution requirement is 6%, but you have that Benny IRA invested. And let's say it's earning at least 6%. So that means you take out the six grows right back. That could go on a whole lifetime. So as long as you're earning enough interest to replenish what you're taking and the principal stays intact, that's why they called it a stretch IRA, because it
Because
could
you'd
stretch
never have
out.
to pay taxes on your principal if that kept happening.
Correct, but I think the point is just that it can keep going on. And so
Yeah.
when the let's say the children inherit it, and this happens, and they take the distributions, and it's earning enough interest and it keeps the principal intact, then that could even pass on to their children. and go
Yeah.
on to the next generation and continue on. Well,
That's the way it was.
that's the way it was. And that's
Yeah.
what the Secure Act changed. So,
Mm.
our government is looking for tax dollars. Congress is in desperate need of tax dollars and
Yep.
isn't always about changing the tax code. Sometimes they will monkey with other rules in the legislation that will create taxation sooner. And so that's, I think, what the play was here. And ultimately, the Secure Act now says this. So if somebody passes away after 2020, and then the next generation inherits that IRA, they can't stretch it on forever. The way the rule works now is if that person passed away at a required minimum distribution age, which is now age 73, okay, and it was after 2020, then when the kid inherits that IRA money, they have to take the same kind of required distribution based on the life expectancy formula for the first 9 years. And then by the end of year 10, all of the money has to be out of the IRA. So you could be taking incremental distributions for 9 years and the money could be growing right back. But come year 10, now I call it like a balloon payment, where now you have to take it all out at once and pay all the taxes on what's remaining, which could definitely shoot you up to further tax brackets. And what that's doing is it's creating more tax revenue faster than allowing this to continue to stretch on for lifetimes. So that was a big rule change. And this is where things get tricky for a lot of folks, again, that don't keep up with this, because what if somebody passes away and they're not at a required minimum distribution age? Now, when the child inherits it, they don't have to take distributions for 9 years, but they still have to have it all liquidated by the end of year 10.
Yeah. So they took away the stretch option, and the rule is it's a little different. If you an inherited IRA has a lot of rules, and I'm glad you're talking about this. And if our listeners have questions, I encourage them to set up a consultation with you, because it's different if you're a spouse than if you're the children, right? There's a difference
Correct.
there too.
Yeah. So the spouse, again, just takes over the IRA as their
Right.
own. They don't have to necessarily, they don't have to take out, there's not a 10-year rule. They may have to take distributions, but that's all depending on their age at that time.
Hmm.
Right. But I also want to touch on the Roth as it relates to the Secure Act,
Okay.
because that's a little bit different. Where if you inherit a Roth IRA, okay, you don't have to take required distributions. Why is that, Tony? Why do they not make you take distributions out of a Roth?
Because a Roth was after tax money that went in, and so it grows tax free. There are no taxes on a Roth,
Yeah,
so they
so
don't care.
they don't care because they're not going to benefit. They're not
Yeah.
forcing you to take it out year over year because it's not generating a taxable event. But they still don't want something as good as the Roth to go on forever. So the rule with the Secure Act on the Roth is that you don't have to take the distributions for the first 9 years, but you have to have it all liquidated out of the Roth by the end of the 10th year. So what typically would happen in that case? They take the money out of the Roth in year 10, and then that means that money is going to go probably get reinvested back into an individual or joint account, otherwise known as the taxable bucket, which means you'll have a cost basis on what came out of the Roth and went back into a taxable investment account. But then as it grows from there, what's going to happen?
Yeah.
Taxation.
Tax.
So
You're going to get
now they're going to
taxed.
get more taxes. So they
Yeah.
don't want the Roth to go on forever. So, I think that's why there's a lot of moving parts with all of this. And of course, then in 2 years later, January 1 of 2023, they came out with the Secure Act 2.0. And without getting into all of that, the big takeaway there related to our topic is that they changed the required distribution age. So for as long as many of the years I've been in the business, over 25 years, okay, it was always 70 and a half. And then the first Secure Act of January 1, 2020 changed the RMD age from 70 and a half to 72. And then literally 2 years later, Secure Act 2.0 in 2023, they changed the RMD age to age 73.
Right.
And then starting 2034, it's going to go to age 75. So if that's not enough to make your head spin, right? It's a lot to keep up with related to the rules of these accounts that most Americans, tend to have, as that's the typical go-to for contributing to retirement, are these, IRAs and 401ks, which ultimately have these effects that happen down the road.
Yeah, a lot of rules mostly relating to taxes. There are a lot of strategies involved when it comes to inherited IRAs, whether it's a Roth or a traditional, or just getting your beneficiary designations in order. Making sure you review those if you have major life changes like marriages, divorces, weddings, births, these deaths in the family. It's huge. So, how can our listeners out there, Ryan, get a hold of you to set up that no charge, no obligation consultation?
Absolutely. So you can give us a call at area code 615-467-6300. You can also email us at info@rsgtn, or check out our website at rsgtn.com.
All right. Well, that sounds great. Great show. A lot of information jam packed in this one, Ryan. Thank you so much, listeners and viewers. Thanks for tuning in. That does it for today's episode of More Financial Talk with our host, Ryan Moore.